Hey, movers and shakers, today I'm going to be discussing the 5 most vital terms and conditions that you must have in your contract, whether it's on your BOL or in a separate terms and conditions sheet that you must have initialed, signed, and dated at the end so that there's no confusions with your shipper and yourself of what you're responsible for and what they're responsible for. And these specific 5 will prevent you from being scammed pretty much guaranteed along the line. Okay? So make sure you have these 5. We're going to go over it and why the importance of each are. So stay tuned right after these brief messages, whatever they may be. But let's get into it. Okay, movers and shakers, let's get into it. Let's get off with some preliminary rules. First of all, when you're talking about terms and conditions, you've got to make sure that your terms and conditions are signed, right? You've got to make sure that they're signed and dated by all parties involved. That includes yourself and your shipper. So how you got to do that is you're going to send them out through DocuSign. And if you don't know how to use DocuSign, it's very simple. You just go make an account with DocuSign. You upload your documents. DocuSign will then you point out the areas that need to be signed. And then when they get sent out with your email, the link for your DocuSign downloads, DocuSign will then take your shipper through the procedures of signing the documents by adopting a signature, et cetera, giving them the waivers that they need to understand that by signing electronically, it is the same as signing in person, and so on and so forth. And a good thing about DocuSign is that not only will the shipper be able to download their signed copies, but it will send to you their signed copy as well. So you just have that in the DocuSign account, and you can send that out whenever you want in your standard emails, etc. So you've got to have that set up. You got to make sure that first of all, you send out an email letting them know that your customer, your shipper, has got to sign some information before the move. And this is key. You can't have them sign them the day of or at the time of the move, because that doesn't really give them the chance to read through and ask any questions. You got to give them, just out of courtesy's sake, you got to give them the ability to sign the documents before the move. Right? And then set up your account with DocuSign. And again, if you don't know how to do it, there are plenty of videos that are really, really short. It's really simple to set up, but there are plenty of videos on the YouTube University where it'll show you how to use DocuSign effectively and easily. All right, so those are the basic rules. Remember, you got to get it in writing, and you got to get it sent through some sort of system like DocuSign. Now, if you want to use something other than DocuSign that's just as good or better, by all means use, but that's just to give you an idea of what you need to use, right? Secondly, when you're doing your estimate and you're booking the move for your business, one thing I would do is say, hey, look, someone's going to give you a call from my office, and we're going to go over the paperwork, and we'll show you how to go, and we're going to go over it on the phone with each other, or you can do it by Zoom call or however you want, where they actually fill it out. You can actually take them step by step through everything that they need to sign. Right now, a lot of like if you're buying real estate, there will be a transactional person who will take you through the documentation, and that's something you should be able to set up, or should set up, whether it's yourself or somebody in your office. That would be a really good item to add to make sure that the stuff gets signed in a timely manner before the event of the move, right? So just think about that. Obviously, if you're a small company, you don't have to have it, or you're not going to be able to afford to have that, but it's definitely something that you should have. All right, so let's get into the top 5 most vital terms and conditions that every contract should have and that will protect your behindie. All right, let's get it. Number 1, failure to pay equals no claims and 3 times the reimbursement plus legal fees, etc. Now, this is vital because, we're going to get those customers that are just not happy with our services. It's going to happen. So in those cases, we got to protect ourselves. So you don't want to argue with the customer at all. You don't want to make them feel bad, or you don't want to invalidate them, because that helps no one, and it only helps their resolve to be an FU to you and not pay, right? So one thing to do that you might want to enjoy is putting this term into your terms and conditions, that if there's a failure to pay for whatever reasons, bounce check, insufficient funds, just an unwillingness to pay, you are going to be charged 3 times the unpaid amount, plus attorney fees and legal fees, etc., if it goes to that extreme, right? So it's not a problem. So if you got a customer who refuses to pay, you're like, no problem, ma'am or sir. Look, if you don't pay, then I'm going to have to escalate this to a legal responsibility to get you to pay, and I'm going to sue you for 3 times the amount that you are unpaid for, so that I can recoup my losses, plus any legal and attorney fees that might be a resultant of such escalation of this terms. And usually that'll get them to change their mind. Secondly, it's got to be part of that all claims, any claims that they have, are hereby null and void until that is resolved, right? So if they're saying they're refusing to pay because of damages for some reason, then all claims are null and void until the matter is resolved. And we're going to go over that in a little bit later here down the line about that exact same terms and conditions. Let's go to number 2. Number 2, misrepresentation of service results in additional costs. So I know that a lot of you guys, you do a lot of your estimates over the phone. So inside your terms and conditions, yes, you should be sending terms and conditions. Even if you do an estimate over the phone, you should then make sure that they're aware of this situation, that if they have misrepresented, whether intentionally or unintentionally, could result in additional costs. You have to have that. And you should have a published a la carte menu of those additional services and their costs, right? So you should have that. If you don't have that, then it becomes this nebulous thing of additional costs, and then you could be considered or perceived as a moving scam. So let's just get it over with. Go and get a additional services and cost list made up. You could do it right on your computer using Microsoft Word or Google Docs or whatever you want. You can make it look pretty, however you want, but you should have the service and its cost, service cost, and just have 2 columns, one with the service, one with the additional cost, and be done with it, and send it out with your estimates and so on and so forth. But that should also be a term and condition within your contract. All right, let's go to number 3. Insurance will be at 60 cents per pound per item, period, unless otherwise paid for valuation, right? So when in your contract, in your terms and conditions, it is automatically setting forth that you are only going to pay 60 pounds per item, per pound per item, right? Because by law, if you do not have that and they don't sign on, initial it, then by law, you are responsible for full valuation insurance. This is a misunderstood or completely ignored rule in our industry, right? Where movers think that, it's 60 cents per pound. I'm only going to pay 60 cents per pound per item. No, if they have not signed off saying that they want that insurance rate, it is automatically full valuation. Here's the kicker though. If they don't want to sign for the 60 cents per pound, then you can upcharge them for the full valuation insurance. It's totally okay. And so great. Let them know, look, if you want full valuation, it's automatic, but I'm going to charge you an additional $200, $300, $400, $500 or whatever that you're going to be charging for it, unless you sign off on the 60 cents per pound per item. Then that way that protects you, and that gets you, so if you ever got to go to court or you ever got to file a damage claim, you can say, look, you signed off on the 60 cents per pound per item. I have it in writing. This is all you're going to get. Sorry that your stuff was damaged, but this is what you agreed to when we did this. So you got to make sure and cover yourself when you're doing that. And don't get confused thinking that it's an automatic thing, because it's not. It is not. It's against the law to just give them 60 cents per item if they did not sign for it. So they got to sign off saying that's what they want. All right, number 4. You will not be responsible for any improperly packed items such as TVs or press board or pictures, etc., mirrors, whatever. If it is not packaged professionally and properly, you will not be responsible for its damage. TVs are the biggest example of this. Flat screen TVs are horrible. They get easily damaged quite easily. So if they're not done, put in a professional packed box like its original packaging box, or in a TV box that you have. You are not responsible for them. And this includes mirrors. This includes paintings and pictures and so on and so forth. Because those need to be packaged in a very certain manner so as to be safe when being transported. And if the customer's doing their own packing and they pack it in just some sloppy box, then you're not going to be responsible for its damaged items, right? Also, within this, although I didn't write it down, you're not responsible for anything that you did not pack personally. So if you did not put it in one of your boxes, whatever it is, if you did not put it in your box and package it up, you are not responsible for the contents inside that box. You don't know if they packaged what they put in the box. You don't know if they packaged it right. Maybe it's a bunch of dishes and they just didn't put any paper in it, and then through the jiggling and stuff, all the plates get broken, or wine glasses, etc. Well, you don't know what's in that box. You don't know how it's done. It's on the customer, and you got to have yourself protected with that term and condition. Otherwise, it is on you. All right, now let's get into number 5th one, the last one for this video. Claims must be within 30, 60, 90 days, whatever you decide, right? And must be paid in full before claim is accepted, right? So if there's any damage claims, you've got to put within your terms and conditions that you will accept claims within 30, 60, or 90 days. Whatever your terms is. Maybe it's only 30 days they got a chance to do it. Maybe you give them 60 days, or maybe you get in 90 days or 120 days. Whatever it is, you got to give them in writing whatever that length is. Now, by law, you must give them 9 months. Legally, they have 9 months to make a claim. And a lot of you new movers think you can just not accept anything after 30 days. And you technically can't if you have it in writing. But by law, they have up to 9 months to make any kind of claim regarding their items. So be aware of that. So put that number inside your terms and conditions, and they initial it afterwards, right? And you must make it say that all bills must be paid in full before they can make any kind of damage claim, because you're not going to accept their damage claim if they're not paid in full, right? You've got to have that in writing. It's got to be it's got to get signed and dated, the whole work. So they can't go and say, for instance, if they fail to pay, then there is no damage claim. You are not given any kind of damage claims, period, none. It's not paid in full, right? And if you have to take them to court and you're going to charge them the 3 times the unpaid amount, then guess what? The damage claim cannot be done until they're reconciled with however much they have to pay, whether it's by legal means or by whatever the bill, right? So must have this in there, and you must have it initialed. In fact, I recommend that all of these terms and conditions that I've laid out here all get initialed when in the terms and conditions. So you might have a list of 20, 25 different terms and conditions. I would specifically have these specific 5 that are initialed outside of just regular being signed at the bottom of the document with its date. So have these specific ones initialed. So that highlights the importance of these particular 5 different terms and conditions. Just my recommendation. You don't have to do it, but I recommend that you do. All right, guys, hopefully this is helpful for you. And whether you're a mover or some other idea, take these 5 different terms and conditions and apply them, adapt them to your particular business. All right, guys, I like you. I love you. Go and do something great today.